Carter, Richards Bay hear me? Obviously not. Great. Thank you. Thank you. All right, I apologize profusely for being an hour late. I think I told some of you I had to go to court for a plagiarism case, which is still not finished. Okay, so for this exam that you're about to write, my best advice is if you start with tutorial letter 102, which is the latest or updated version that I uploaded on Monday evening. And the reason for that is because I tried to update the diagrammatic representation of constitutional law in that diagram. Because when you open your study guide, you should see a diagrammatic representation of constitutional law, which most of you probably just didn't look at because you thought, well, it doesn't really mean anything, I'll come back to it later. But if you do look at that diagram, and I now have updated it so it doesn't look identical, but that diagram is everything you need to know for constitutional law. Because you start by looking at the concepts that are just stated broadly at the top of the page, on the left. So you'll see I state constitutionalism, and then a little bit below it I write separation of powers, and then rule of law and democracy. That is because those concepts are absolutely fundamental to every single thing about constitutional law. So let us start then with what constitutionalism as a concept means. Constitutionalism has a number of elements. Those elements are, in a state that professes to be a constitutional state, South Africa being your example, there is a supreme and entrenched constitution. We do have that. Our constitution is supreme. It's the highest law of the land. We know that all law and all conduct must comply with the Constitution, and if it doesn't, it must be declared invalid. So that's the first element. The second element of a constitutional state is that it is a state where there is the rule of law. South Africa most certainly gives the impression that we have the rule of law, because Section 1, subsection C, says to us that the state of South Africa is premised on the rule of law. Now you read Section 1 telling us that South Africa adheres to the rule of law in conjunction with other provisions of the Constitution, which then prove to us that it is true that the rule of law prevails. Those sections would include Section 165 of the Constitution, because it is in 165 that it tells us that the judicial authority of the state is vested in the courts, and that the courts have the mandate and the power to arbitrate all allegations of unconstitutional law or unconstitutional conduct that come before them, and that the court can grant appropriate relief. So that you'll probably know from Section 38, which if you're doing fundamental rights, you probably will have come across, and it's repeated in Section 172 of the Constitution. So you see how a lot of provisions are mutually reinforcing. So we have a state that has a supreme entrenched constitution. We have the rule of law. And in conjunction with that, we have the separation of powers. Now, you may recall that in Glenister 1, so at the end of your study guides, I included a brief summary or just an explanation or even just one line of most of the cases you have to know for constitutional law purposes. And Glenister 1, it literally has one line. It says, the separation of powers is axiomatic in South Africa. That means we can't see it because the words separation of powers are not written anywhere in the Constitution, but we know it's there because of the structure or the construction of our Constitution, and because the constitutional principles which were drafted to enable a new constitution to be written at the end of apartheid, that document with these 34 constitutional principles stated that South Africa will have a separation of powers. So before we discuss separation of powers in more depth, because separation of powers is the crux of constitutional law. But other elements proving to us that we're a constitutional state are that we have an independent judiciary. Not just any kind of judiciary, but a really independent judiciary that has the power to judicially review the law or the conduct that is alleged to be unconstitutional. And we know we have that. As I just said, Section 165 states that we have this independent judiciary that has the power to declare law or conduct. Yes, thank you. I don't think so. I think we were okay. Thank you so much. So Section 165 says it's the judiciary that has this power to act in a manner that is without any fear, favour, bias or prejudice in determining the matter before them. And then Section 172 of the Constitution qualifies what it is that the judiciary can do, because it says that it is the judiciary that must declare the law or conduct invalid. So then the fifth element of a constitutional state is respect for fundamental rights. And we do have that. We know we've got an entire Bill of Rights which unambiguously protects and promotes the fundamental rights of each one of us, whether we are citizens or not, irrespective of the color of our skin, language we speak, even our sexual orientation, for example. So all of those elements combined prove to us that we're a state that is committed to having this Constitution and to giving meaningful effect to the Constitution. So that then brings us to just down, a little bit further down on the page, I write there, rule of law. And you must know then that rule of law does permeate every single thing in the whole of the Constitution. So rule of law, what does it mean effectively? It is that no one, not even the president, is above the law. It means that the law is already drafted, it is known, it is clear, unequivocal as to what behavior is deemed acceptable and what behavior is an offense. And moreover, because you'll see, if you do have a copy of the Constitution, the actual substance of the Constitution doesn't say very much, does it? When you read it, it just says everyone has the right to dignity. it hasn't explained and interpreted what dignity means. That's why one of the elements of the rule of law is that the rule of law is given meaning by the judiciary. That's why we have all these court cases that you have to know for constitutional law. It's those cases that have given content and substance and flesh to the law, so that we actually now know what kind of conduct is acceptable and which isn't. Then democracy, I've got it just inside there, but democracy is also foundational to our entire constitutional system. Yesterday's elections are a case in point. So I'm going to discuss democracy in the context of the separation of powers, because you will see then how fundamental having a democratic system is to having a properly constructed constitutional system that works as it was designed to. So one of the elements that I didn't mention, but it is regarded as being an element of constitutionalism, is that the state should practice a multi-party type of democracy. So let's interrogate democracy then. In South Africa, we don't just have one form of democracy operating at any given time. Simultaneously, we have 5 forms of democracy. First and foremost, we are a constitutional democracy because we have the entrenched Supreme Constitution that you know of, that subsumes within it the rule of law, and it therefore means that because the Constitution is supreme, all law and all conduct must comply with the Constitution. That's what a constitutional democracy means. And that the judiciary is constantly monitoring the work of the executive and the legislature to make sure that the Constitution is actually being upheld and not being eroded or undermined. So that's constitutional democracy. Multi-party democracy is another one, but in relation to multi-party democracy is that South Africa practices representative democracy. Now that is the epitome of our legislative branch of the state. I say that because, and I drew a picture. I don't know whether it works, but I think some students are sort of visual learners and some are auditory learners. So I try to explain the separation of powers and the counter-majoritarian dilemma using pictures. So they're just little icons. But if you look at those pictures and read, obviously, the narrative, what I was conveying is the following. Every 5 years in South Africa, we have a democratic multi-party election. How those elections actually come to happen is that prior to every election, all of the political parties that wish to participate in this election on an equal footing, they all have what's called an elective conference. Each political party then chooses the list of candidates that they, as the party, are endorsing to be members of Parliament. So they formulate a list, and of course the ANC's list will have about 400, it should be 400, but 400 odd names that now have been vetted by the people, because we are allowed to look at those lists and comment, and people have been commenting, like I try to illustrate. People have said, what about Batabile Dlamini and Malusi Gaba? They shouldn't be on the list. And so on, of course, I said, we'll consider that, but let's just do it after the election. So he is being responsive. But what happens then is we don't vote for a person, we vote for the party. And then the party's list is used to determine how many seats in Parliament that political party earns, and it's based on the proportion of votes that the party has received. So in the case of the African National Congress, which has usually got about 65%, there's always about 258 ANC members of Parliament. And then because the DA would have about 20%, there'd be 80 DA members. And then the EFF would have 10%, so there'd be around about 39. Depends really on how the calculation works, because it's something like 2.2% per vote, and it's a very complicated calculation. But it is indicative of the fact that we have a perfectly representative Parliament that ably illustrates the will of the people. Because based on the general will, so 59% of the population want the ANC, then 59% of the members of Parliament will be from the ANC. So that whole process of putting those members there into that position is part of the democratic multi-party system that we use in South Africa. And that is then, as I say, the epitome of the representative democracy that we have emphasized at length. So once those members fill the positions, you'll recall, and you probably have heard this, that we're now about to establish our 6th Parliament. And that's because it's now the 6th time that we've had an election, and these members might all be brand new people. There might not be any who've been carried over from the previous Parliament. So it's new people, new blood, new ideas, hopefully, because what is the function of Parliament? Parliament is there to pass laws, amend laws, repeal laws for us. We can't all be sitting in Parliament debating and adopting these laws. We have to sort of distribute our power to these people who we trust to make the laws on our behalf, and we expect them to act in good faith and to operate on the basis of constitutionalism and upholding the values within the Constitution. So then what is the safeguard? The safeguard is Section 1 of the Constitution again, which is the same provision that's already told us that our Constitution is supreme, that we are premised on the rule of law, that we are a democratic state. But it is that provision, Section 1D, that says we are a state premised on an accountable, open, responsive government. Now, I generally don't like to call the legislature government because, in narrow terms, the executive, to my mind, is better term government because the executive is implementing the laws. So that's, to my mind, the better way of explaining that's what government does. But the Constitution calls the legislative and executive branches government. So and I suppose it is right because we have democratically elected the people in Parliament, and they are drawing up the laws and formulating these new policies. Well, hopefully there's a two-way street between them and the executive. So they are giving expression to our needs and our interests. So we can call them government, but then the implementation...
Sorry.
Yes?
Sorry. Would that be correct to say executive is one and the same thing as the state?
No. You'll notice this more and more with recent cases where the Constitutional Court specifically will use the term state, and the state means the legislature, executive, and the judiciary. Because that is how the state functions optimally. It's because you have all three. Whereas government is really only executive and to a certain extent the legislature. Whereas the judiciary is not part of government. It's completely independent and autonomous. So the state, I like the word state because it's important for constitutional law if you realize that we are this territorially defined geographical area that is completely independent of anyone else. We are sovereign. In other words, we can make decisions for ourselves, and we have a president who can speak for us externally. And as a state, if you've done international law, you will be doing it soon. As a state, South Africa is recognized by the rest of the international community, and as a state, South Africa can ratify international treaties such as the Rome Statute of the International Criminal Court. The government only speaks for the state internally. And that's why we call the president the head of state and head of the executive, because he actually does have a different role to play as head of state. That's where he has to receive other heads of state. Go and meet them at the airport, because he's got to show his respect for their sovereignty and their status as the president of another sovereign state. Whereas government is really only at the local, or not local in literal term, but domestic or national level, implementing the laws for the people. So state is the umbrella term for the government and, of course, the judiciary. And that's why in the diagram I have other terms at the top and side of the page that I haven't dealt with at all yet, but those are also part of the state, not part of the government. And we're going to come to those. But my emphasis then is on the fact that this democratically elected legislature must be accountable and open and responsive. And that's why in Tutorial Letter 102, there are 7 cases. So it's the electronic version of the 102. In the hard copy one, I think there are 6 cases. Yes. I know I'm confusing you, but all the cases were in the hard copy you received, except for the AfriForum. I just included AfriForum because I'd like to show you how Chief Justice Mokoena is actually decolonizing constitutional law and is showing his frustration with the slow rate of progress towards the vision that was the new constitutional dispensation. So I'll talk about AfriForum a bit, but essentially there are 3 cases, in fact we can say 4, let's say 4. There are 4 cases in Tutorial Letter 102. Those cases are EFF 1, EFF 2, UDM. All 3 of those are against the Speaker of the National Assembly, and then DA versus Minister of International Relations and Cooperation. Now, interestingly, you'll notice all 3 of those are brought by political parties. And that is indicative of our democratic system, where we have opposition parties holding the majority in government accountable. So, you already know the facts of the 2 EFF cases and the UDM case. But let's recap. So the facts of the 2 EFF cases are, as we all know, extensive security upgrades were conducted at former President Zuma's Nkandla homestead. And it became clear that some of these upgrades were not entirely security related. So a number of people were aggrieved by this fact, and knowing that they're aggrieved, but knowing that it's going to cost a lot of money to go to court, where did they go to lodge their case? Yes, so that right at the top right of your diagrammatic representation I've got there. Chapter 9 institutions. And for constitutional law purposes, we really only need to care about the public protector and the IEC. Now, I've already alluded to the role of the IEC by saying we've just had a national election, national and provincial. The IEC has been working for 5 solid years in anticipation of this election, making sure that ballot papers are going to be printed on time, that the marking pens are there, that there's staff to officiate the election, that there are now members of staff who are willing, able, and available to count these millions of votes. And it's also obviously their role to receive those lists from the political parties beforehand, publish them so that we're all on the same page about who exactly are on the lists. And of course they are supposed to register each of the political parties, and we know that they made a mistake and they apparently failed to register the BLF, which the BLF are still contesting. So they did make a mistake. But in the grand scheme of things, they generally know what they're doing by now. The 6th election we've just had, and they do a pretty good job. So we know that what their function is to make sure that we have free, fair, democratic elections. But it's the public protector that really is this threat hanging over the executive branch of the state. Because while it was President Zuma who was receiving these upgrades, he is head of the executive, meaning even though he's the president, he's not above the law. And that's why a number of people, so individuals who are not necessarily politically aligned, as well as some members. Yes.
Has the BLF case created a precedent?
No, I think it's not over yet. I think they are able to appeal and say, look, there was enough publicity to the effect that we were actually intending to be registered. We paid our fees on time. It was an oversight. So I think that they can apply for.
So currently, are they not on? Are they
No,
not
they
gazetted?
are. They are on the list, and they.
I know they're only,
contested.
so they are gazetted now as we speak.
No, I think it's not yet. I don't think.
Is that not constitutional?
Yes, but that only happened a week ago. I don't think it happened so quickly with all the things that were happening. But it can be condoned. That for everyone knows that they should have been registered.
What was the constitutional?
I don't think so. It's not such a fundamental issue that it's going to cause a constitutional crisis.
Sounds like a serious discrepancy to me.
Yes, it is, but it's also, I think, something that can be explained away. That the IEC can say, we had 48 parties. We had done the initial process of registering the BLF just at the last days that something happened. Please excuse us.
I hope we won't nullify our elections then.
No. I honestly don't think that would happen.
Okay.
No.
As long as one comes with them.
No, and I think even the BLF realised that it isn't a absolute bar to them contest. That's why they continue to contest the election as though there is no problem, because it's an easily rectifiable situation. It's just obviously quite unfortunate. So this public protector is watching and can therefore be approached by anyone, and that's the benefit of the public protector. It's free and it's relatively quick. Litigation is far too time-consuming, far too expensive, and it's not appropriate very often when there is a single institution that is constitutionally established. So in Section 182 of the Constitution, unambiguously says a public protector shall be established, or the office shall be established. And the most important part is, what is the mandate of the public protector? It is to investigate all allegations of maladministration, abuse of power, corruption, malfeasance. So it's a very broad mandate, and that's why sufficient resources are supposed to be given to the public protector to make sure that the investigations can actually be successfully concluded. And we've noted that the current public protector and, of course, the previous one, Thuli Madonsela, are much more active than previous public protectors. And what we are seeing is that these reports are being produced and now being handed over to the National Assembly, which is what Section 182 says, that the National Assembly is the body that must receive the reports from the public protector, and that is because the National Assembly is our representatives speaking for us. They are the ones who must say whether or not those allegations are true, and therefore they must invoke their powers in terms of Section 55 of the Constitution to actually hold the relevant people accountable. So your National Assembly then plays the very important role of making sure that the executive is accountable. So you can see that check and balance. But the point being made is that we are in a system where there are independent, autonomous institutions watching over the effective functioning of the legislature and, of course, most importantly, the executive. So the EFF1 case is essentially that this report was produced 14th of March, March 2014, by Thuli Madonsela, given over to the National Assembly with the expectation that something should be done, because the Public Protector's report specifically said the President must pay back a sum of money. She didn't decide how much it should be, because she also understands that that's actually not her job. That job is the person who had done the work. That's why the Minister of Public Works, the Minister of Police who was overseeing it, they knew all the terms of the contracts, how much it actually cost. They were the ones who should decide. She didn't have to decide how much it should be. Parliament should decide it by asking the Minister of Police and asking the Minister of Public Works, give us information. So what Parliament did, because of course it's a politically sensitive issue, this is now the President that's an issue, they tried to find ways to exonerate the President and make it look as though they were actually applying their margins. They first sent the report to the first committee, ad hoc committee, and as its name indicates, and you'll see in the Constitution, ad hoc committee is sort of for a short time period, and it's got sort of wide powers. It can just deal with this specific issue, and then it doesn't have to exist after that. And so the first committee said, we found absolutely no wrongdoing on the part of the President, so we don't think he needs to do anything. And then us, because of course now the EFF, DA, UDM, COPE would all say, in fact we've seen it at the State of the Nation address, pay back the money. And so they kept saying to the Speaker of the National Assembly, you're not really doing your job. You, as the Speaker of the National Assembly, are tasked with making sure that this legislature functions the best it possibly can, and you are responsible for making sure that the work of the National Assembly is actually undertaken. And one of those functions, as we know from Section 55, is to hold the executive accountable. And so the Speaker of the National Assembly, you will have seen when I start document 102, I call it, or I start with the title of The Personal is Political. And then I talk about Sujit Chowdhury's article, which is right at the back of your study guide. I give a summary, and it's I think on page 38 or 138 of the textbook, where this article by Sujit Chowdhury is mentioned. And it's actually a really interesting, thought-provoking article, because it does speak to the problems in South Africa. So Sujit Chowdhury, who is of Indian origin but living in Canada, you'll remember that South Africa adopted many of the Canadian systems when drafting our own constitution. So he's speaking from a position of experience of how things should be in theory. And his concern is that South Africa has a dominant party democracy. The ANC is too dominant or has been too dominant thus far. And his words then are that the pathology or the sickness of this dominant party democracy is the colonization or capturing of independent institutions. The Speaker of the National Assembly is supposed to be an independent institution. She's colonized. Well, she now no longer will be shortly, but she was colonized by her allegiance to the ANC and her, there's a respect for the president and her need to protect him. So that's why she would try to avoid having to deal with votes of no confidence, for example, and avoided actually taking a stand on the Public Protector's report because she couldn't separate the party from the state. Now we know that's true of her. It's true of President Zuma himself when he was president. He himself would often say the ANC comes before the state. So we see this conflation.
Excuse me?
Yes.
Does that now mean that with the public protector having written the report and given the recommendations, nothing can really happen until the National Assembly decides?
Yes, that's why the EFF2 case is important. But yes,
So these are the decision or the recommendations of the public?
no, that's exactly the point. That's actually the point of EFF1 case, is that if a constitutional body, the public protector, has original constitutional powers to make an investigation, come up with recommendations, they are given to the National Assembly only to implement those recommendations, because the investigation's already been done by a competent body.
So is it more of an order?
It really is an order, but there is a little bit of discretion given to the to the National Assembly, because that's what the Constitution says, is that the Speaker of the National Assembly must enable the National Assembly to come up with its own rules and regulations about how best to achieve its objectives. So it does give it a little bit of latitude. But in general, and that's where there was such confusion before, when those recommendations are given to the National Assembly, and the words that the Constitutional Court used is that the National Assembly can't disregard them willy-nilly and just ignore them for an irrational reason.
And they have given a time frame to act on what
Yes, they do. They say within a year we think that you should have given a recommendation. And in fact, in the past, when the public protector has been given this mandate, she has concluded her investigation pretty quickly so that she can get it to Parliament as soon as possible and they can start implementing immediately. And that's really the essence of the EFF case, is that the National Assembly failed to act until the EFF said, this is now enough. We can't carry on like this. We are here to hold the executive accountable, and therefore we are going to make sure that this is done. And of course, they then had to go to the judiciary.
Excuse me, can I please interrupt?
Yes?
Would you kindly every now and again just face your
I know.
laptop and look at us?
I will
We
do.
feel excluded
I know.
completely.
Okay.
Thank you.
That's fine, yes. That precedent has already developed now, that the National Assembly now knows that they can't just delay, that they need to act. What does Section 237 of the Constitution say? It says, all constitutional obligations must be undertaken without delay and diligently. So you see how you have to read various sections of the Constitution together to prove, and that's what the court does, to prove that the National Assembly had failed to act quickly. And because they didn't act quickly, this was a constitutional violation. So I'm using the EFF case, the facts there, and I'm already now addressing that we have these three principal organs of state. But you know what they are, so that's not too confusing. But really, if you had to give in an exam the definition of constitutional law, you need to say constitutional law is that branch of public law that is concerned with how the state functions in constitutional terms. In other words, how the three principal organs of state are established, what their powers are, what the limits of their powers are, and it's implied that there must be appropriate checks and balances to make sure that there's another branch of state that monitors the work of the legislature or that monitors the work of the executive to make sure that the constitutional provisions are adhered to absolutely or 100%. So the National Assembly, and I sort of overshot this part, but what you probably are aware of, but just to bring it to your attention again, is that when our National Assembly sits for the very first time after the national election, they give effect to another form of democracy. They then speak on our behalf, so it's representative democracy, but it's also a form of direct democracy, because it's those 400 people who speak for us when they hold an election just with the 400 members there present, and it's them who votes to elect the state president and head of the executive. So because they have chosen the president, our constitution then also says it's they that can remove the president. And that's where the EFF1 case evolved to. So EFF1 has now qualified and made absolutely clear for all future matters related to the public protector that the decisions of the public protector are enforceable, binding, implementable, without much debate. There's a little bit of room for debate, but in general terms, and I'll get to what the little bit of room for debate is, in general terms, it's now the National Assembly's obligation, whether they like it or not, to hold the executive account, irrespective of whether it's the president or any other member of the executive.
Sorry.
Yes?
Hello, hi.
Yeah?
I view the delay by the National Assembly regarding the enforcement of public protectors' recommendations to the Nkandla upgrades the same as the delays by former President Jacob Zuma on the fees must fall recommendation of the Commission of Inquiry for Higher Education, fees must fall. Now my question is, what would you advise one to tackle a question that would, for instance, say the implications of the delays, the implications of the delays regarding the implementation of the recommendations of the Commission of the Commission of Inquiry for Fees Must Fall versus the delays by the National Assembly to act. How would one tackle that question?
Oh, that's a great question. Look, I think that the provision of Section 237 of the Constitution, which emphasizes that all constitutional obligations must be undertaken without delay and must be done as effectively as possible and as quickly as possible. I do think that the distinction is that a formal investigation by the public protector in the case of Nkandla was very clear that the undue enrichment or benefit derived by President Zuma was a quantifiable amount, and therefore it could quickly and easily be repaid without implicating other branches of state or having what we call polycentric consequences. And I'm coming to what that means, because if you are doing administrative law, which I think most of you are doing it simultaneously, you probably have already come across this concept before. So in the case of fees must fall, where the president, in good faith, appointed a task team to give him advice on whether fees for higher education should be zero or should be structured in some other way. He did this in his capacity as head of the executive, but the recommendations he received were most certainly not the kind of recommendations that can be implemented overnight. There were so many different countervailing and competing considerations that all had to be taken into account, that the president really did have to take some time and carefully apply his mind to the recommendations and consider all the ramifications. So polycentric decision-making is where in the state, and that's why you'll notice I love using the term state instead of government, is because if you envision the state as a circle, where within the broader circle of the state, there's a smaller circle for the money that has to be allocated for education. There's a smaller circle for healthcare, a smaller circle for housing, a smaller circle for social welfare, a smaller circle for land reform, for all sorts of the necessary costs of running the state. And if the president then comes along and starts saying that we must just find 50 billion rand to cover education, it's going to be like pulling on a spider's web, where you start pulling on, taking money out of education, or rather, it's going the other way around, sorry. Start taking money out of healthcare to move it to education to cover that shortfall. It's going to pull the entire cobweb, spider's web, to a disproportionate shape where it's going to affect every other little circle. So that's why there was a delay. There was a delay because the president realized this is going to have far-reaching circumstances that we actually might not even be able to comprehend at this stage. And of course then, as time went by and he was trying to get sort of into everyone's good books again, is when he suddenly announced, we're going to have free education. But all of those workings about how it's going to work in practice hadn't been fully considered, and that's why it's not yet implementable. It was a premature decision on his part, just like we saw President Mandela making a premature decision in the case of Executive Council of the Western Cape, where he said, oh, I'm the president, I can just amend the law, and he couldn't because he hadn't allowed Parliament to follow the process of actually allowing him to make such changes. But even more importantly, we've seen cases where the president has acted before he's actually allowed to. So your admin law cases are relevant here, and this is the Nuclex case, where the president, was it Nuclex? Pharmaceutical, yes, that manufacturer's case, yes, where he said, I promulgate the New Medicines and Related Devices Act, and suddenly they realized that law was invalid because Section 55, which deals with the actual regulations, the regulations have not yet been formulated. So how can we have a law, yet it can't be implemented because there are no regulations yet? So it was a premature decision. So we have a similar situation here, where if you now need to contest it, you'll find that political parties, for example, will be able to go to court and say, President Zuma, in his capacity as head of the executive, made this decision, but we are seeking a judicial review of the decision because it is unimplementable and it's going to have serious consequences and repercussions for the functioning of the state. So EFF 1 then is clear about the role, the mandate, the powers of the public protector, and that they are directly implementable. EFF 2 is really just a development of it. It's exactly the same set of facts, but it now deals with the fact that the EFF approached the High Court and they said, we are not satisfied by the fact that the National Assembly was allowed to play those games where they delayed by going to one committee and delayed by going to another committee. We are coming to the Constitutional Court on an urgent basis and an exclusive basis. So you know that Section 167.4 says that the Constitutional Court is the only court that can declare whether or not a constitutional obligation has been forgotten to be attended to or not implemented properly. And so that's why the EFF went to the Constitutional Court and they said, we want an order that even though the Constitution says that the National Assembly has a wide amount of discretion to decide its own workings, Section 55 of the Constitution actually says that the National Assembly must create appropriate methods, mechanisms, committees, and bodies to make the relevant decisions. And therefore, the EFF's argument was that the National Assembly, but they called it the case against the Speaker of the National Assembly, because her role was to make sure that these methods and mechanisms were adopted. But she was actually, that's how we see in cases, it often says NO, doesn't mean number, it means nomine officio, in their official capacity. So it's the Speaker in her official capacity was supposed to ensure that these methods were put in place, but she didn't. And that therefore the whole National Assembly had not performed its function, because someone should have said to her, look, we should be doing this. But the essence of the case is that EFF 2 has now confirmed to us that even when a report by the Public Protector, for example, comes to Parliament, or when there's another court case that says the President has violated the law, and we've seen that in the case of DA versus the President of the Republic of South Africa, where the DA versus the Minister of International Relations is probably a better case, where the whole executive was now being subverted for political ends, because when South Africa did not arrest and surrender Omar AlBashir when he'd come to South Africa in 2015, that was a serious violation of the law, because our law says that we've not only ratified at the international level the Rome Statute establishing the International Criminal Court, but we then domesticated the law in terms of the implementation of the Rome Statute of the International Criminal Court Act of 2002, and that act says unambiguously, when anyone who is wanted by the International Criminal Court arrives in South Africa, the minute they set foot on the territory, they're supposed to be arrested. Yet, Omar AlBashir arrived, he attended some of the African Union meetings in Sandton, and then the government was sued. So it was the government of South Africa that was being sued for not immediately arresting him. And because I started by saying to you, the President receives other heads of state, the President equally knows when heads of state are leaving. So when the court case was being heard, so you've seen in the cases, the Southern African Litigation Centre went to court and said, Omar AlBashir is not allowed to leave the country. Please can this Gauteng North High Court in Pretoria make this decision? They did make the decision. While that way they were busy making that decision, and counsel for the government was arguing and saying, we promise you there's no intention of us letting Omar AlBashir leave the country, we will arrest him. At that material time, Jacob Zuma will have given the order saying, you drive Omar AlBashir to the Waterkloof Air Force Base, bring his aeroplane from the OR Tambo Airport, put him on the aeroplane as fast as you can and let him fly out, because otherwise we have to arrest him. So the government, and when I say government there, I'm talking about the executive part of government, the president, and the Minister of International Relations, who should have been making sure that we do comply with our international obligations, they were willfully obstructing our international obligations, and consequently, because we were embarrassed, the case of DA versus the Minister of International Relations was heard by the Constitutional Court, because here we were failing to comply with our obligations, and we were now making it worse by trying to withdraw from the Rome Statute as if to say, well, we weren't really bound by this in any event. If we are a country where the rule of law reigns supreme, then we should have implemented the law. So the point I'm making is that the president is at all times accountable for his conduct, as are the ministers, and it is usually the political parties that help to hold the president accountable, because it's the political parties that very often have the money to be able to go to court and argue the particular case. So the EFF1 case was about the fact that now the president must pay back the money, but the second part, as I said, now getting to it, is where once that decision, I think you might have seen this in the video I did on Tuesday, this very weekend that's just passed, Jacob Zuma once again said, I don't know what I've done wrong. No one can tell me what I've done wrong. If you read just these few cases in your tutorial letter 102, there's no doubt in your mind about what he's done wrong, because the courts are saying, on this date he did this, on this date he did that, which constitutes a serious violation of the law and of the Constitution. But the point that is made in EFF2 is that while it is the National Assembly's role to administer its own affairs the best way it sees fit, that's its role, no one can tell it what to do. Even though the judiciary were now being asked, you must tell the National Assembly how to manage their affairs, what mechanisms to put in place. The judiciary, in our constitutional democracy, knows the limits of its powers and doesn't go further than it needs to do. And that's why all it said is, yes, EFF, we agree with your case. There's all the valid arguments you've made have so much merit. We agree that the National Assembly must create these mechanisms. But we actually can't tell them what those mechanisms are. But they must ensure that from now onwards, when there are these court cases or public protector recommendations given to the National Assembly that indicate that the president or anyone in the executive, any cabinet member or deputy minister, has failed to comply with the law, then a mechanism must immediately be created, and that committee, which is going to be composed of a number of representatives of the ANC, the DA, the EFF, Freedom Front Plus, all together, they first have to decide if what the member of the executive has done is a serious violation of the law or a serious violation of the Constitution, or, based on any other circumstances, if the president is no longer able to perform the functions expected of him. So now there's a two-step process in place, where first that little committee needs to make this decision and say, yes, there's a violation of the law, serious. They have to define serious as well. That was what was so wrong with the 6 votes of no confidence that came to nothing anyway. No one really had an idea of what the definition of serious violation is. So that's why the Constitutional Court has now said, you as Parliament must establish the meaning of serious and establish, based on the facts of each incident, if it is serious misconduct, because it is a violation of the law. And only once that subcommittee has decided because that's what the National Assembly's role is to hold the executive accountable. Yes?
May I interrupt for a second?
You can?
You are saying that the committee appointed by the National Assembly, right? The committee appointed must then interpret in such a way, right?
Yes.
The meaning of the serious conduct. Then we go back to the principle of separation of powers.
Yes.
How does that separate the duties of the judiciary to that of the National Assembly if the National Assembly is going to acquire a role of interpreting the law?
Well,
how does that separate those powers?
No, that's a great question, but the response is that, as the court held in the EFF2 case, it's got to be an objective assessment of whether it is a serious violation of the law or a serious violation of the Constitution. And that objective assessment is not made on the basis of nothing to go on. They've got the underlying court cases to convince them about that it is actually a violation of the law. And that's where the discretion of the National Assembly is just to decide whether they think in those circumstances, even though it is a violation, is it sufficiently serious to remove the president? So they do have a certain amount of interpretation to do, but they're doing it based on a decision emanating from the responsible organ of state, being the judiciary, or even the public protector, which we know is a constitutional body with powers to investigate and make recommendations, and based on the expertise of the public protector. So that's how all they're really doing is trying to narrow the focus from he's violated the law by accepting all sorts of non-security upgrades at Nkandla, to simplifying it to, on an objective basis, do we as representatives of the people deem this to be enough to remove the president from office, or do we think that he's allowed certain benefits as president? And the point that is being made by the EFF2 case is that even in all of the votes of no confidence that happened, none of them were successful, but the court said even if they were successful, they actually would have been invalid anyway because this preliminary step had been ignored. So now we know we have 2 steps. And the 2 steps are the small committee. The small committee then decides, yes, this is a serious enough violation to remove the president, and they then propose it to the rest of the National Assembly. And that's why Section 89 of the Constitution says the president may be impeached, it doesn't use the word impeached, but removed from office, if the National Assembly, by a vote of 2/3 majority, votes in favor of the removal. And it's got the grounds there, but now the National Assembly has been given the power to interrogate those grounds a little bit more and actually decide, is this serious enough to constitute the removal? Because they have to make the final decision, speaking on our behalf. So that's the 2 EFF cases. The UDM case is actually very much the same, yes.
Since the judiciary and the executive legislation are all independent, the legislature is where the laws are made, and the executives are the members that are elected. How is legislation independent from the executive, or the coalition?
They are separate. In fact, that's an excellent point that I did mention, that the president is elected by the National Assembly, and then the president gets to choose his own cabinet, and he can reshuffle his cabinet. We know that he's allowed to do that. All we expect, though, is that he does it on a rational basis and can justify and substantiate why he's done it with the record and the reasons. So the DA versus President of the Republic of South Africa case in your 102 explains that, where the President does have a large amount of power, but he must be able to justify to everybody else. And the way that this happens is that the National Assembly calls and can even summons the members of the executive to come to Parliament and explain to them what have they done. And that's how the legislature watches the executive and says to them, to the Minister of Social Welfare, for example, how could you let it happen that in April 2018, people didn't know whether they were going to get their social welfare grant or not because you didn't make sure that a new contract had been entered into. So there's the National Assembly that watches the executive, and there is the judiciary and the public protector, actually, that watches the executive. So your question was, how do we make sure that there is?
The separation of powers between the legislature and the executive.
Well, that's where Sujit Chowdhury says we've got such a dominant democracy that's the difficulty. And that's why he was arguing that there's this colonization that's happening, where our independent institutions can't make rational decisions. That's how the president Jacob Zuma never did get voted out of office, because the ANC were too dominant. But I think that is changing. These court cases that keep emphasizing the rule of law and the need to uphold the constitutional duty bestowed on the representatives of the people is, I think, infiltrating. And that's why, and it's a great point you've come to, we've seen now with Thabo Mbeki and with Jacob Zuma that what the ANC have done as their own method of accountability to protect themselves as the party and that individual is to rather recall them. Because what does Section 89 say? Section 89 of the Constitution. Unfortunately, it says, if the president is removed because of a serious violation of the law or a serious violation of the Constitution, they lose all their benefits. No pension, no medical aid, no house to live in for the rest of your life. So that's where the ANC have realized, look, we've made a mistake with not voting Jacob Zuma out, and we are therefore going to take, I think the words of Cyril Ramaphosa were, corrective measures, recalling Jacob Zuma rather than letting him be humiliated and voted out of office. They recall him, and then a person who is seen to be the democratic, legitimate leader of the party that everyone can trust assumes the position. So there's an internal political process of accountability and these constitutional processes that sometimes fail.
And it's also constitutional, because you can't have rules that's against the Constitution.
Yes.
So then it's within the framework.
Yes, absolutely. So the whole idea is about recalling the president is it constitutional? That is. There's nothing that prevents the political party from having processes in place to remove someone who really, if you want to use the terminology of Section 102 of the Constitution, that they've lost confidence in. But remember the very serious consequences of a vote of no confidence in terms of Section 102 is that if there is this vote of no confidence by the National Assembly against the president, that president is not the only one who falls. His entire cabinet has to resign. The deputy ministers have to resign. It causes an impediment to the administration of justice, because now you wake up one day and there's no Minister of Health, no Minister of Education, that all new people have to be appointed. That's definitely not a desirable outcome. And so if the political party can come up with a resolution that's better and is going to have a seamless transition, why not? It is constitutional. It's in the interest of the effective functioning of the state. Even though a vote of no confidence, you need to know, or should know, you only need a a simple majority with 50% plus one. Not even a whole extra 1%, just one single other person. That's why it looks easier. It is easier. In fact, that was the issue in the Mazibuko versus Speaker of the National Assembly case, is that the DA said the country has lost faith and confidence in President Zuma. We want a vote of no confidence. But the National Assembly, well, spoken through by Baleka Mbete, said, no, I'm not even putting this on the roll. Who are you? You're just a minority opposition party. You have no right to ask me to do this. And that's when they had to go to court. And the court said, you as the Speaker must allow a minority opposition party to be able to put forward a vote of no confidence, and it must be debated. So you see and that's where the UDM case, which I'm now finally talking about, resolves that there must be a process in place to enable any party to bring in a motion of no confidence, as the UDM did, but the UDM were wanting something more. They were simply asking, they had said to the Speaker, we want this as a secret ballot. She kept saying, oh, I don't think I have the power to do it. You know, it's not within my power to make such a decision. That's when the UDM had to go to the Constitutional Court, and the Constitutional Court, again, to answer your question more directly, does respect the separation of powers and the limits of its powers. So it didn't say to the National Assembly, you must make it a secret ballot and you must do it this way. They said, you as the Speaker have discretion to decide for yourself whether or not it should be a secret ballot, because you have that power inherent in your position as the Speaker. So you see, all of these cases have now confirmed for us that we have a clear separation of powers, that we have the three independent branches of the state that all do actually know what they're supposed to do, and they do watch each other, and for the most part, except for one rogue President, Zuma, for the most part, everyone did comply with their functions. It just is unfortunate, and this brings us to the Corruption Watch and Kasana case that you also need to know, which is in the end of your 102, is that President Zuma, unfortunately, became too embroiled in political he was captured, let's say. So too embroiled in political issues that often caused him to act in certain ways out of a sense of desperation. Because you'll know from very recent events that the Commission of Inquiry conducted by Yvonne Mokgoro, the former Constitutional Court Justice, into the fitness to hold office of Lawrence Mrwebi and Nomqobo Jiba. And the decision that she came to was that they're not fit and proper, they should not be within the NPA. But the issue was that they were doing President Zuma's bidding. They were making sure that certain people, like President Zuma's son, were not investigated for allegations of impropriety. And that's why there was the acrimony, as the court says, between Nkosana, who was independent, and Jiba and Mrwebi. And it was the common denominator is that Jacob Zuma he had certain people in his pocket to do his bidding, and it corrupted the entire independence of the National Prosecuting Authority. I'm going to discuss the Nkosana matter further, but are you with me then? If you are in the exam and you are now having to answer a question, as you're going to have to do, I would like that if you understand this diagram and you've got it in your mind, you can quite easily see that there's the three organs of state, they're all independent. You know then how the National Assembly is constituted, because you understand what constitutionalism is, what separation of powers is, what democracy is. And then you understand, okay, we have this National Assembly, that passes the laws on our behalf. And then the fifth form of democracy is that we have a participatory democracy. So we don't just sit back and wait for 5 years for the next parliament to fulfill its position or fill its positions, and then we just carry on functioning. We are actually supposed to be taking an active role in monitoring what laws are being drafted by the National Assembly, and when the public is asked to make comments on a draft bill, they must do so. So that's where participatory democracy has its essence, is can we participate in the decision-making processes that are going to have an effect on our life? And it's through the legislative process that we do this. And that we need case law as support for this. You know I love referring to the Merafong case and the Matatiele case, because in those two cases, in both instances, very similar facts. The provincial government, and so when I talk about separation of powers, you know from your diagram that it's in the national sphere, in the provincial sphere, and the local sphere. And they all actually do exactly the same thing. But the provincial sphere, provincial legislature, in the case of Matatiele, said, let's just move Matatiele out of KwaZulu-Natal into the Eastern Cape province. The people weren't happy because the process of participation was fundamentally flawed. It wasn't a case of, what is your opinion? It was, we are going to do this whether you like it or not. Even more so in Merafong, where, yes, and we call that sort of, well, betrayal. It's betrayal. Even a form of seduction when you say, coming to get your opinion, but in fact they've already made their mind up long ago, and they're imposing this decision whether you like it or not, and that's why the people of Merafong said.
It's a perception. It's just perception. That creates a perception.
Yes, that they've consulted with the people.
Going through the motions.
Yes, but in fact the decision was made long ago. It was going to be implemented regardless. And that's why the people of Merafong said, we will make this place ungovernable. And it became a war zone. Because they said, no one's listened to us. Okay. So, also, one question I get a lot is there a difference between sphere and level? And there is.
Sphere.
Level of government. So my little diagram, the first one, but I tried to make it more sort of apparent in this latest version, is it's actually a circle around the national sphere, a circle around the provincial, and a circle around the local. That is because a sphere is a circle. When you understand that during apartheid, the form of government taken from the Westminster system was such that the national government had all the power. They had so much power that they could delegate some of their powers to the provincial and the local levels. So the national government could say to the provinces, in all of the 4 provinces that there were, you will not allow any black person to live in a white area. And those provinces had to agree whether they liked it or not. And then it had to be replicated at the municipal level. So the municipalities, the mayor of the town was told, you will not allow a black person to live permanently in this town. And the idea there is that there was this hierarchy. The national was on top, it had all the power, they delegated their powers to the lower levels, and the idea that if you delegate your powers to someone else, you can take those powers away. And that is precisely what happened, is the lower level, the municipalities, were the handmaidens. So they had to just do what the national government said they had to do.
It's like parliamentary supremacy, basically.
Yes, precisely. What the national parliament says, no one can contest. We have the final say. We'll do what we say, and if you don't do what we say, we're taking your powers away from you. So to prevent that, the conscious decision was made that in the democratic dispensation, we're going to have spheres of government. Spheres literally means each of the 3 spheres have their own original constitutional powers. No one can take those powers away from them. So that's what's the difference between sphere and level. Level was unconstitutional, problematic, because it didn't actually devolve the power to the local level where the power is exercised most for the benefit of the people. So that's where you need to know that there are 3 spheres, but they all actually do the exact same thing. At the national sphere, we have our National Assembly, National Executive, and the judiciary is not part necessarily of government, as I've mentioned. So I've put it there, Constitutional Court and Supreme Court of Appeal, because they like courts at the national level, but they are more encompassing than that. They can hear cases from throughout the country on now all matters. The Constitutional Court has very wide constitutional jurisdiction and can deal with, according to the 17th Amendment, any matter that is of public interest if they decide that they should hear it. But as you've seen, the Constitutional Court is so busy anyway that it probably is going to not hear cases unless they are really typically constitutional cases. So at the provincial sphere, we see exactly that. The provincial legislature, provincial executive, Premier of the Cape, Premier of Gauteng, Premier of Eastern Cape. That's exactly like the President, but just at the provincial sphere. Also, you have NECs, the ministers. They're the ones who are responsible for implementing the laws passed by the national government, but specifically by the provincial government. And then I put there high courts, because there are high courts in every one of the provinces. But we aren't too concerned for constitutional law purposes with what the judiciary does, because they are independent. So that question about how do we make sure they are independent, we know that our judiciary is completely independent and is not subject to any political interference by the legislature or the executive. But then at the local level, and I say level because it just sounds easy to say, but remember to say sphere, because it is now at the level of the municipal or the Metropolitan Municipal Council of Cape Town, it's not feasible to have an entire legislature and an entire executive. So it's actually the same people. They're democratically elected, but it's the same people who then draft the bylaws and ensure that they're implemented at the same time. That's where we have our councillors. They're the ones who are debating these laws and they're ensuring that they're implemented. And that's why you have Metro Police, for example, they're helping to implement at the local sphere. And so importantly, I need you to recognize that in the diagram I have dotted lines from the Judicial Service Commission and the National Prosecuting Authority to the judiciary. That is to signify that both the Judicial Service Commission and the National Prosecuting Authority are completely independent. They are independent of the judiciary and independent of the executive. Importantly that they're independent of the executive, because what if the executive tries to interfere with the National Prosecuting Authority and telling them who they can and can't arrest? We've seen it. That's why Thabo Mbeki was recalled, because the Scorpions, who were a highly successful investigative body, were so successful that they came across incontrovertible evidence that Jackie Salebi, a high-ranking ANC official, the police commissioner, and the head of Interpol, was accepting bribes from Glenn Agliotti so that the Scorpions would not investigate Glenn Agliotti's drug dealing, etc. And as soon as President Mbeki was told the Scorpions are about to arrest Jackie Salebi, he said, "Don't do it until I tell you to do it." Do you see that that is political interference? Yes. So the idea then is that the National Prosecuting Authority must be completely independent. So let's quickly discuss the Judicial Service Commission first. Judicial Service Commission, you all have a fair idea. Its function, in terms of Section 178 of the Constitution, is to be this large body for 23 people who are part of the Judicial Service Commission. Those 23 people are tasked with the enormous responsibility of making sure that the members of the judiciary are fit and proper, and that they continue to act in a manner that is of the right integrity, honesty, competence, credibility, that they are functioning as the judiciary is supposed to function. In other words, how to make sure that the members of the bench are independent, impartial, arbiters of the facts and the law, and are not going to be subject to any interference. So we know that there are a number of mechanisms to make sure that the judiciary remains independent, such as security of tenure, fixed salaries, and good salaries at that. But it is the...
Excuse me?
Yes?
Yes, I'd like to ask, what are the limits of presidential pardon, and doesn't that influence the judiciary as well? Thank you.
No, that's an excellent question from your administrative law course. Section 84 of the Constitution is the one that sets out what the specific powers of the president as head of state is. And one of those that only the president can exercise is to provide a pardon. It's a kind of decision then that is a purely constitutional decision. It's not administrative. He's not implementing any law doing it. He is exercising his purely constitutional power bestowed exclusively on him, and he gets to decide whether or not a person or groups of people should be pardoned. So, of course, we saw it in the Hugo case, where President Mandela said, I realize that there are lots of women prisoners who have young children at home. I'm going to pardon all of those women prisoners if they have children under the age of 12 at home. And that's when Hugo objected and said, but I'm a father of young children who don't have a mother. I should also be released. Yes, but the court said, unfortunately, the general characteristic of society is that it's the women who have the caregiving function, and therefore the president can only, he's perfectly entitled to only pardon women. So, of course, the Dalindyebo matter is probably foremost in our minds, and it is going to be exceedingly interesting to see what President Ramaphosa, I'm sure he will continue, as President does, because of the highly political background. He's not just a citizen, he is King Dalindyebo. But he probably will be released on the presidential pardon because he's getting old and he's elderly and he's got this status in society. So
much for rule of law.
But it is still rule of law because the president gets to apply his mind again, gets the advice of the Minister of Justice and Correctional Services, who'll say, look, he's not a threat to society any longer. You know, there should be a Sheikh got a presidential pardon. Why can't Dalindyebo? Yes.
Just a quick question. In terms of the legislature being empowered constitutionally to hold to account members of the executive, if there is prima facie evidence against a member of the executive in terms of wrongdoing or malfeasance, and that person is called to account in terms of whatever committee they're called to by the legislature, the person subsequently or prior to appearing resigns. What happens in this case? And in terms of the legislature continuing its mandate, could it be, let's say, that the latest sort of corruption commission which has been established by the president with to undoing the web of state capture, is that an extension of Section 55 of the legislature carrying out its mandate, or the executive and the legislature carrying out the mandate to make sure that proper bodies are put together to find sort of what took place? And furthermore, in terms of that, obviously that commission doesn't have the ability to prosecute, but then the judiciary would take over and would then be the important balance in terms of ensuring a criminal prosecution, a fair criminal prosecution takes place based on the evidence which was provided by the commission.
Yes, very good. I mean, that's precisely the sort of the link I like being made, is that just like the public protector has these far-reaching powers, commissions of inquiry, and we know it's controversial that, but the Constitution says the President can appoint a commission of inquiry, but there's no clarity on whether the President must implement them. We are getting to the point where it's clear that the President, in terms of the rule of law, is implementing the decisions. We've seen it now with the Mokoro Commission of Inquiry. We are inevitably going to be seeing it with the Zondo Commission. There's so much incontrovertible, insurmountable evidence that no one can contest that there wasn't widespread corruption. And so the President is, in furtherance of the task of ensuring accountable, open, responsive government, is having these public commissions of inquiry so that the knowledge, it's like the process of the TRC. Bring the knowledge to the people so that we all are aware and we can move forward on the basis of that information. It's not just secret. So I'm probably not really getting to your answer to your question, but in general, it's all an inherent part of making sure that the state works optimally, and that's why I have those dotted lines from the National Prosecuting Authority to the judiciary, and not to the executive, but remember, it's from your assignment. There is that sui generis relationship between the National Prosecuting Authority and the executive, in that it's a distant relationship where the executive cannot tell the National Prosecuting Authority.
May I interrupt, please?
Yes?
Just for a second. May I interrupt for a second, please?
Yes.
You spoke of the presidential power to pardon prisoners, right?
Yes.
And you spoke of maybe circumstances that needs to be taken into consideration, stating the status within the community. Would you agree with me if I was to say that in some way or another the law does not apply equally to all?
Yes, unfortunately it does. It most certainly does. But I do think that there is, in President Ramaphosa's case, he is far more in tune with the needs and the wishes of society, which is, and I'm going to bring in the AfriForum case discussion very briefly here, just to reinforce what you're saying.
I'm asking that would you agree if I am to say that the law does not apply equally to all, as if it's falsely stated in the Equality Clause, Section 9, Subsection 1 of the Constitution. The law does not apply equally to all, right?
Yes, but what I'm trying to get to is that is true. That certain people in South African society continue to derive more benefit and are viewed as being higher on the hierarchy than others. And that's why the AfriForum case is introduced in your 102. I want you to see that we are now 25 years into democracy, and you can sense Chief Justice Mogoeng's frustration with the fact that for so long the legacy of apartheid has actually been continuing. And that's why he refers to things like the fees must fall protests. And he says he knows that there is still this seething anger in society because some people seem to still be benefiting from white privilege. And therefore, Dalindyebo is probably going to benefit from a different form of privilege. So there are some people who are better off. But what Mogoeng was trying to put across in the AfriForum case is that's got to come to an end. So when AfriForum ran to court saying, how dare the Tshwane Municipal Council change the name of Pretoria to Tshwane, and how dare they change the name to Nelson Mandela instead of Jan van Riebeeck, for example, Mogoeng said, we cannot allow a society where the majority still feel alienated and that they are less deserving and that they are a lesser citizen. So we are getting to a point where we are going to be all equal. Of course, we've been talking about it for 25 years, but we still are on the road to that. And that's why I put AfriForum in, because I wanted to realize that we, also by the fact that in more and more judgments, Mogoeng is speaking or writing in Zulu, for example. He's speaking to the people. So he is trying to decolonize and transform constitutional law because we are still perpetuating many of the injustices of the past. I must admit, driving from the Mitchell's Plain, to the Mitchell's Plain court and from the Mitchell's Plain court to Pero today, the massive injustices that are the legacy of apartheid. It's shocking, really, that people are still living in such inhumane, undignified circumstances. Why haven't we moved forward? But very quickly, I do want to end the lecture then, since it's almost 7, purely by saying the Judicial Service Commission has this enormous task, as I've said, of making sure that the judges are fit and proper. If you were to be asked, have they succeeded? You probably would have to answer that no. They have succeeded in appointing fit and proper judges. Mogoeng, one of them, even though he was highly criticized when he was interviewed. But unfortunately now, we are seeing, or 10 years ago rather, is when it happened, we saw when Judge Hlophe, who is the judge president of the Western Cape, he knows the law, he swore an oath of office when he took office, saying, I will uphold the law. Yes?
Hi.
Yes?
Sorry, I just want to check with you. I think partly one of my understandings, or something that maybe I had assumed, was that part of the lecture would be to sort of give us some form of idea on what to concentrate on.
I think I have done that. Yes, I am doing that.
Can we also come in, please?
Yes?
Yes. Am I online?
Is it Bloemfontein?
Yes.
Yes, speak.
Yes, Bloemfontein. No, we want to make a submission. I think the latter speaker, we want to agree with her. And our submission is that we want to humbly plead with colleagues that the intention of the lecture today is to prepare for exam next week. Now, if maybe we can focus on those issues, some of the issues which we are raising are debates, it's fine. Unfortunately, this is not an ordinary class where we can debate these issues, but if we can humbly prepare for exam and focus on those issues, we can debate it in terms of how we see issues of pardon and all those things.
Well, I must admit, I think I'm doing exactly what...
No, you are doing quite well, but we are simply saying...
Okay, yes.
I'm humble pleased that when colleagues deposit questions to you, they should deposit questions which seeks to assist us to prepare for examination.
Yes.
And the ladies sit next to you. If she can also.
Hello. Yeah. Can the lady sitting next to you, when she moves, she makes a lot of noise. If she can just minimize her movements there, the children get.
I don't think that noise is here.
The noise will not be here.
Okay.
So please, can the class be as such for preparation of the exam as it was requested? Yes, we have to address some of the issues, but can you try to avoid not to dwell? Can you just, in passing, when you address the question that is being asked, not dwelling too much, so that we can move ahead to the other study units?
Well, yes, and in fact.
Like maybe 2017, like something like that.
Well, in fact, yes, that is pretty much what we are doing. Well, nothing specific, but it's very much based on 2017 November. Okay, so I'm going to where this lecture is heading to. Yes, Richards Bay.
Yes, we are saying that we like the way you're doing things. We very much following your style. We do understand that this is an exam prep. We like the way you're doing things. Can you please continue this way? So that's what we are saying.
Well, I promise you that actually what I'm doing is directly geared towards the exam in any event.
We are following and we are gaining a lot. Thank you.
Yes, so you will notice.
You said something about November. What were you
Yes,
saying about
no,
November?
I was referring to November 2017 exam, which was the kind of paper you're going to get now. A set of facts, questions based on it. So those facts are going to be something that's relevant, topical. That's why when we speak about Dalindyebo, for example, in law, there is not always one single right or wrong answer. You might be able to bring in AfriForum or Dalindyebo's situation in your answer. But the essence of constitutional law is that there are three principal organs of state. They are independent of each other, but there's a relationship to make sure that there's accountability. And that's why we have this Judicial Service Commission. Even though some of the members of the Judicial Service Commission are politicians, they are supposed to relinquish their political allegiances while deciding, is this person the right candidate to be a judge in the Constitutional Court? Do they have the right temperament, the right experience, the right qualifications? And so if the question is, has the Judicial Service Commission been successful? You would probably want to say, for the most part, they've been successful in appointing good candidates. But when it comes to removing candidates who are impairing the integrity of the judiciary, they have not done very well. And that's where the Hlophe case is so important. Because in April 2008, so over 10 years ago, Judge John Hlophe went to Johannesburg to the Constitutional Court, spoke to two different judges, mostly in Zulu, saying, you are our last hope, you must find in favor of our comrade. And they both instinctively knew that what he was referring to is the Constitutional Court's decision that was pending against, or likely against, Jacob Zuma because of allegations of corruption and collusion with French companies that had unduly benefited Jacob Zuma. And so what those two judges did is they immediately went to the Chief Justice, Pius Langa, and they said, we've got this problem. And that's when Pius Langa drafted a complaint to the Judicial Service Commission. Even though he's the chair of the Judicial Service Commission, he knows that he must step away and put someone else in his place, although there wasn't anyone to be in his place because it was all 11 Constitutional Court judges who brought this application. But they said, this sentence said by Hlophe does improperly influence the judiciary. He is trying to change the outcome of an independent court. And what the Judicial Service Commission did is they didn't want to deal with this highly sensitive case, so they rather just said, we don't have the jurisdiction because we don't have a judicial service tribunal. We haven't had all the information from Judge Hlophe because he hasn't given us very much information. We're just going to close the case. But this case is important because Freedom Under Law then went to the High Court and said, you need to make an order telling the Judicial Service Commission to reopen the case because they have not dealt with this properly. And of course, Helen Ziller went to court in her own right because Section 178(1)(k) of the Constitution says that the Premier of the province where that judge presides must also be part of the judicial service hearing when there's a decision about the removal of a judge from a particular province. She wasn't invited. So there were two separate decisions telling the Judicial Service Commission, you have failed to comply with a constitutional obligation to hold a member of the judiciary accountable and to remove him if it is deemed to be serious misconduct. And we are still waiting for that judicial tribunal to actually deliberate on this matter. They do keep... Yes, that's what they had to do. That's when the Freedom Under Law decision elaborated that the Judicial Service Commission needed to establish this special tribunal that had the requisite powers and ability to remove a judge. Then the National Prosecuting Authority is similar. The person who is the National Director of Public Prosecutions must be fit and proper. And as you'll see then from the Corruption Watch Nkasana matter, that for the last decade at least, our National Prosecuting Authority has not been the epitome of an independent, impartial body. It has been paralyzed by instability, as the court says, because Vusi Pakoli was head of the National Prosecuting Authority, then he was suspended, then there was a commission of inquiry about whether he's fit and proper to hold office. He was removed, also with a settlement agreement, so he was paid to leave. That indicates to you that certain people were being removed because they were too independent. When Vusi Pakoli was removed and paid a settlement figure, he was replaced by Menzi Simelane. Now we all know, and I'm sure that he lied under oath. That's not a fit and proper person. So when it was found that he'd lied under oath, of course, or revealed that now he was the new National Director of Public Prosecutions, even though he actually isn't fit and proper, the DA rushed to court and said, this person is not suitable to be the head of the National Prosecuting Authority. And then it was when Mxolisi Nkasana was appointed, and at first everything was fine until that acrimony between himself and Nomqobo Jiba and Lawrence Mwebe, who were trying to pave the way for certain cases for Jacob Zuma's benefit. And that's when Jacob Zuma decided, I can't have Mxolisi here anymore. I'm going to threaten him by telling him I'm going to institute a commission of inquiry to establish his fitness to hold office, because unfortunately for Mxolisi there was some evidence that he had a prior conviction for a physical assault against someone, a serious assault, and there were some other allegations about cases that had been brought against him, but he didn't reveal that to the president. But in any event, the writing really was on the wall that The president wanted Mxolisi out, and that's when he said to Mxolisi, how much money do you want? And Mxolisi said, I'm not going anywhere. Through Michael Hulley, Zuma's legal advisor. Then he even sent him a settlement letter and said, you fill in how much money you want. Have anything you want. The people will pay. And that's when a figure, well, there was still some resentment on the part of Mxolisi. He said, I'm not going. Why must I go? But when he said, okay, well, I'll only go if you pay me 17.3 million rand, Jacob Zuma said, that's fine. Why not? 10 million is going to go to the taxman anyway, but you've got 7.3 million. Go. And Nkosana reluctantly left. So that someone malleable, susceptible to corruption, could be put in his position. We can't necessarily make any or cast aspersions against Sean Abrams because the court itself said no one's actually ever said that Sean Abrams isn't fit and proper. But the fact that he was pushed in that position under such dubious circumstances does impair the integrity of the independence of the institution of the National Prosecuting Authority. And that's why the final decision was that the president had to appoint a new National Director of Public Prosecutions within 90 days, and he did so. And I think we've now settled on someone who is seen to be incorruptible, has worked out of the country for so long that she's not likely to be politically manipulated. So that then is the majority of your diagram. Then at the bottom, I've just got two small things that are necessary to say, which is if you understand how the big diagram works, you would be able to explain that the counter-majoritarian dilemma is not a dilemma. So the counter-majoritarian dilemma is where, how can we have 400 elected representatives who've passed a law and one judge can say, how dare you 400 people pass this law? My decision is more important than yours. That looks at the opposite of the majority rules. But it's not a dilemma because Section 1 says we're premised on the rule of law. Section 165 says the judiciary must decide cases without fear, favour, prejudice. Section 172 declares that the judiciary must invalidate any law or any conduct by the executive if it is undemocratic. And the reason it says that in our constitution is because our constitutional drafters, our parents, and in fact, as you might know, it was seen to be a democratic process. Everyone was asked, what do you want to see in this new constitution? And people were given an opportunity to say, I want to see an independent judiciary, because during apartheid, the judiciary had no powers. So, non-existent virtually. They had no power to decide anything on substance of human rights, for example. They could say, oh, the procedure hasn't been followed. But even then, if the Parliament didn't like it, they'd overrule it anyway. So that's where this independent judiciary that has the power to declare conduct invalid has been granted in the Constitution, and that's why law can be declared invalid. And then on the side, I've got the idea of how our multi-level government system operates, and you need to obviously be aware. If it is a case where you're talking about concurrent competencies between the national sphere and the provincial sphere, and when it says provincial, remember there's a part A for provincial and part B for local. So what do we do if they're concurrent, or just have an idea in your mind? Schedule 4, concurrent are issues that it's all right if the province or the municipality passes a law on that, because we know that the national legislature can't pass laws on every single thing. So they do leave certain things where they say to the province, you can also pass laws on this if you want. Liquor. That's why we know the liquor bill case. Province provinces, you go and deal with your own issues, for example. We haven't got time for that. And then how do you resolve a conflict? Because conflict can arise. You simply go to section 146, which says if there is already a national law in place that is uniform, that already deals with uniform standards or minimum standards for service delivery, then there's no need for this provincial law to exist if it's going to contradict that national law. And so therefore the general rule is, therefore, in such a circumstance where there's concurrent jurisdiction, the national law should prevail over the provincial if it's going to cause any kind of antagonism or irregularity in how the state as a whole functions. And then when it comes to exclusive competencies, and here we're speaking of things that only the province or only the municipality should have to deal with, like refuse removal, because you can't expect the national government to be saying, in Cape Town, Khayelitsha will have refuse removal on a Tuesday, for example. You leave that to the provincial or the local sphere. And of course, section 147 says, if there's a conflict, go to section 44.2, and that's why it was in your assignment. So 44.2, just have an idea. What are the principles that prevail to enable you to decide which law prevails? And so section 44.2 says to us, if there is already a law in place that deals with essential economic unity or minimum standards for service delivery or national security, that's a very important one, or general national standards of we want a clean society. So it's not even only service delivery, but general national standards. And then, of course, the very important fifth one is if there are already rules and this new rule is going to fundamentally impair or prejudice not only that province as a result of this new rule, this new law, but could even affect the entire state, then of course that law can't carry on being valid. It has to be deemed to be invalid and overridden by a national law. And then this is really the last thing I need to say, which is we held our democratic elections yesterday. And it was the national election and the provincial election. So what is the primary functions, interdependent, interrelated functions of provincial government as opposed to national government? In other words, why do we have a provincial sphere and provincial government? We have it because, firstly, that is that direct link between the voters and our government. So the first one is the link between government to ensure that we have a government that, and I'm talking about provincial government, that can address the specific or unique geographical circumstances of each province. So that's why we have these provinces. The second reason why we have provinces is to, and this is very important if you understand just what it is that the executive does, the answer is apparent here, implement all of the national and provincial laws, especially those relating to service delivery. And thirdly, it is, remember I just explained to you that there's a difference between a sphere and a level of government? Even though we have a sphere of government that gives autonomy and individual original powers to the municipalities or the local sphere, they do still need to be monitored and overseen really by the provincial sphere. So they make sure that the local sphere is actually doing what it should do. Monitoring and supervision is the third reason why we have a province that makes sure that at the grassroots our service delivery needs are actually actually given effect to, that the law is implemented.
Hello?
Yes?
I'm sorry. Could you please repeat the question and I think the first reasoning?
Well, it is on the diagram I sent you. It is in the middle of the page on the updated diagrammatic representation. Just in small letters, why the, well, provinces, and then 3 little reasons for why we have provinces. It's on the electronic version of the 102.
What's happening? What's happening? What you waving for?
It was still recording, I think. It's still recording, even though it's frozen there.